Hi, everybody. Uh, okay, this is Empowering Democracy, and tonight's show is calling Putting the Supreme Court in its Place. I'm your host, Joe Firestone. Your other host, Lisa Theobald, has not been in touch, so I don't know whether she'll be able to come tonight. But we will proceed. Okay, in any case, hello, Steve. I'm so glad you're here. And Dolores, thank you for coming. Thank you for liking, sharing, and subscribing, everyone, if you're on YouTube. Hello, Kay. Nice to see you again today. And Dolores, hi again to you. We evidently have someone who just arrived. It maybe Dolores tuning in on YouTube and on Facebook. So thank you all for coming. I'm going to start off by sharing with you a very good argument about how we ought to put the Supreme Court in its place. This one is by Jamelle Bouie, who is becoming a well-known legal scholar. I found this in Portside. And the title of it is, This is How to Put the Supreme Court in its Place. And a lead-in paragraph. There's no consensus for court reform, and there are not the votes for it in Congress. But circumstances do change, often unexpectedly. Should progressives gain the opportunity to make structural changes to the court, they should take it. So Jamelle Bouie wrote this for the New York Times, and Portside was able to grab it. So there's a statue at the Supreme Court, Lady Justice. I've written before about the ways that Congress should restrain an overbearing and ideological Supreme Court using its powers under the Constitution. As you know, I too have written about this and streamed about it frequently. In short, Article 3, Section 2 states that the Supreme Court shall have, quote, original jurisdiction, unquote, in all cases affecting, quote, ambassadors, other public ministers, and consuls, and those in which a state shall be a party, unquote. And in all other cases, the court shall have appellate jurisdiction, both as to law and fact. And here's the key clause, this is the exceptions clause. With such exceptions and under such regulations as the Congress shall make, unquote. The exceptions and regulations are key. Most of the business of the Supreme Court is appellate work. It hears cases that have already gone through the federal judicial process. Dobbs versus Jackson Women's Health Organization, for example, began its life as a case before the U.S. District Court for the Southern District of Mississippi before going to the U.S. Court of Appeals for the Fifth Circuit, which holds appellate jurisdiction over Texas, Mississippi, and Louisiana. If Congress can regulate the appellate jurisdiction of the Supreme Court, then it can determine which cases it can hear, it being the Supreme Court, of course. The criteria for choosing those cases, and even the basis on which the court can make a constitutional determination. Congress could say, for instance, that the court needs more than a bare majority to overturn a federal statute, even if you agree that the court has the mostly exclusive right to interpret the Constitution. Doesn't therefore follow that 5 justices can essentially nullify the constitutional views of the legislators who passed the law, the president who signed it, and the 4 other justices who affirmed it. Constitutional meaning, in other words, flows as much from the elected branches and the people themselves as it does from courts and legal elites. Okay, I want to say right now, and I'm going to say, that these are my views exactly. Well put, they are by Jamelle Bouie, but they are my views exactly. We all, in other words, have the right to interpret the Constitution and to have a view about what is constitutional and unconstitutional. And the idea that the courts, the Supreme Court, has the exclusive right to interpret the Constitution is a view that is anathema to me. But it is the view that is prevailing in the way the political system currently operates. We must change that. In the same way that it takes a supermajority of Congress to propose a constitutional amendment, it should probably take a supermajority of the court to say what the Constitution means, especially when it relates to acts and actions of elected officials. If there is any place for mandatory consensus in our government, it should be in an area where any given decision can have broad and far-reaching consequences for the entire constitutional order. Typically, when I write about these issues, it is all hypothetical, under the assumption that the Congress hasn't ever used its power to shape the court in this manner. But recently, while reading up on legal disputes during Reconstruction, I learned that at one point, Congress attempted to do exactly what I've described: limit the court's use of judicial review to overturn congressional statutes by raising the bar for a decision from a simple majority to a supermajority. At issue was the Supreme Court's decision in Ex parte Milligan. By the way, I studied that case myself in constitutional law many, many years ago at Cornell University. In 1864, Union Army officers arrested a group of Indiana Democrats who had been vocal critics of the Lincoln administration and its allies. Anyway, a military commission authorized by President Abraham Lincoln under a previously issued executive order charged the men, including Lambton P. Milligan, a leader of the Order of American Knights, quote unquote, Order of American Knights, no less, a pro-slavery secessionist group with, among other things, inciting insurrection and conspiring against the U.S. government. Sound familiar, folks? Okay. Milligan and others were convicted and sentenced to death. Whoa. The following year in May, lawyers for Milligan filed a petition for a writ of habeas corpus in the Circuit Court District of Indiana. Shortly thereafter, President Andrew Johnson, who took office the month before in the wake of Lincoln's assassination, commuted Milligan's sentence to life in prison. In the meantime, Justice David Davis, who rode circuit in Indiana, yes, the justices used to ride circuit on horses, hearing cases along with the federal district judge as they moved through the appeals process, reviewed Milligan's petition. Davis did not think that a military commission was the appropriate way to try Milligan, who was a civilian in a state where there was no active rebellion. The other judge disagreed. Their disagreement sent the case to the Supreme Court, which held oral arguments the next year in 1866. Writing for 5 of the 9 justices, Davis declared it unconstitutional to try civilians in military courts when civilian courts were still available. Chief Justice Salmon P. Chase, yes, the very man the Chase Manhattan Bank was named after. Salmon P. Chase, along with the 3 remaining justices, agreed that the use of military courts was inappropriate, but disagreed that it was unconstitutional. The overall judgment on Milligan's treatment was unanimous, but on the constitutional issue, there was a 5-4 split. Quote, for the Chief Justice, unquote, Walter Starr explains in, quote, Salmon P. Chase, Lincoln's vital rival, unquote, quote, the Milligan case was only in part about events in Indiana in the recent past. It was also about the scope of federal authority in the violent present. Chase was well aware that in many parts of the South, the state civilian courts provided no protections for blacks. God bless you, honey.
Thank you.
Only the federal military courts would punish whites for crimes against blacks. Republicans in Congress, still struggling with Johnson for control of Reconstruction policy, were outraged. The Chicago Tribune spoke for many Republicans when it said that this decision, along with another that concerned the ability of Congress and the states to require a loyalty or test oath for former Confederates who wish to serve in public capacity, showed a, quote, deliberate purpose of the Supreme Court to thus usurp the legislative powers of the government to defeat the will of the loyal men of this nation in the interest of a rebellion crushed by military power, unquote. Oh. The remedy for this problem, the Tribune wrote, was simple. Quote, we think the time has come for Congress to pass a law requiring the concurrence of 3/4 or at least 2/3 of the whole bench to pronounce authoritatively against the constitutionality of any act of Congress. And Republicans took heed of the argument. In 1868, as Congress awaited the court's decision in another case called Ex parte McArdle that could undermine its military reconstruction policies, the House of Representatives debated a bill that would require, according to the New York Herald, a concurrence of 2/3 of all the members necessary to a decision adverse to the validity of any law of the United States. So, concurrence of 2/3. Interesting. Democrats condemned the bill as one of the very gravest of all the revolutionary measures brought before the last or present Congress, tending to subvert and destroy the institutions of the country, unquote. If Congress could override the, quote, deliberate judgment of the Supreme Court of the United States, unquote, declared Representative Samuel S. Marshall of Illinois, as recorded by the New York Times, quote again, there would be established a despotism, not of one man, but an oligarchy or a mob elected by the people, but usurping powers never given to it by the Constitution or the people, unquote. Now that guy had some real nerve saying that when the power of judicial review was never given to the judiciary in the first place by the Constitution of the United States. At least never explicitly. It is not in the Constitution. And Representative John Bingham of Ohio, author of the 14th Amendment, and a Republican, but disagreed. Quote, it would be a sad day for American institutions and for the sacred cause of Republican governments if any tribunal in this land, created by the will of the people, was above and superior to the people's power, unquote. The Supreme Court, he continued in a reference to its decision in Dred Scott versus Sanford, quote, had disgraced not only itself as a tribunal of justice, but it had disgraced humanity when it dared to mouth from its high seat of justice the horrible blasphemy that there were human beings, either in this land or in any land, whose rights white men were not bound to respect, unquote. The bill passed the House and Senate, but it was never signed into law. President Johnson simply refused. In February, the House voted overwhelmingly to impeach Johnson, who was eventually acquitted in the Senate by a single vote. After this, as far as I can tell, the Republicans in Congress made no further effort to force the issue. In November, Republicans won the White House with Ulysses S. Grant at the top of the ticket. In 1869, a Republican Congress passed a law that set the size of the Supreme Court at 9 justices. That was up from 8. Court packing, right? Court packing. And provided that any justice over 70 with sufficient experience could retire at full salary for the rest of his life. Yes, it was all he's then, right? Only hises on the Supreme Court. By mid-1870, Grant had appointed 2 associate justices of the Supreme Court who would go on to affirm his policies. Republicans were content that the court was in their hands. The point of all this is to say that disputes over the Supreme Court's power of judicial review are not new. The reforms to curb it, likewise, are not novel. And even if you stipulate that the Republicans of 1868 were motivated by partisan concerns, It is also true that these Republicans, the lawmakers who wrote the Reconstruction Amendments and reshaped our entire constitutional order, grasped a serious problem with the Supreme Court's role in our ostensibly democratic political system. Their experience of the previous decade of Dred Scott and the secession crisis and the war had put court reform at top of mind, even if they ultimately only took minor steps to reshape the institution. But this decision to spare the court the rod of discipline undermined the Republicans' own political project, although they could not see this in the moment. Within 20 years, the Supreme Court would render much of the 13th and 14th Amendments a dead letter, and by the end of the century, the 15th would have almost no impact on life in the South. Of course, the 13th Amendment was the Slavery Amendment. In other words, the amendment that abolished slavery in the United States, outside, of course, of the prison system. The 14th Amendment was the amendment that established equal rights for persons born in the United States, except for women, of course, and that also established that you could not take away things from people without due process of law, except for women, of course. And by the end of the century, the 15th, which was, of course, the amendment which allowed blacks to vote, as the article said, would have almost no impact on life, in the South. Of course, those three amendments became revitalized over the years to some degree. The 14th Amendment, especially, was interpreted in many creative and constructive ways and lies at the center of whether we will have liberty in the United States right now. Despite some of the more interesting ideas that came out of President Biden's Court Reform Commission, there is no chance at this time for serious court reform. There is no consensus for it within the Democratic Party, and there are certainly not the votes for it in Congress. But circumstances do change, often unexpectedly. Should progressives gain the opportunity to make structural changes to the Supreme Court, they should take it. Boy, I couldn't agree with that more. They should take it. I've been advocating for that forever. Democrats in the 21st century should not make the same mistake Republicans in the 19th century did. Let's go a little bit further that I'm sure Jamelle Bouie has contemplated himself, but is not included in this particular piece. How to put the court in place. The first thing to do is to pass a law expanding the court. There are people, of course, who have argued for 4 more justices for the court. As I've said here in the past, I want 6 more justices, because the probability is pretty high that if you're looking for a majority that is anti-corporate, that is pro-women's rights, and that cares about equality of people, you'll want to appoint 6 justices, because if you only appoint 4, it may be that the Biden administration would make a mistake or two in these appointments and uh, not actually leave a majority of the court who would rule well in those particular issues. Anyway, step one for me is to, to pass a law expanding the court by 6 justices and including the exceptions clause in that particular law, so that this crazy court would not be able, under any interpretation, to find the packing of the court to be unconstitutional. Plainly is not unconstitutional, but God knows what this group of justices is going to actually decide in a particular case. So you have to be as strong as possible in your moves against this particular court. So that's step one. Step two, you have to pass laws as suggested by Bowie that require a supermajority of the court to declare laws unconstitutional, or for that matter, executive practices that are written under the color of law as unconstitutional, okay, as well. In other words, the kinds of decisions we've seen, okay, in the Dobbs case, and also in the recent case involving the EPA, that severely circumscribed the authority of the EPA to successfully administer the laws. Those kinds of decisions by the court must be rendered unconstitutional without a supermajority of the court. Furthermore, the Dobbs case must be relitigated immediately with an expanded court. And the Dobbs decision must be rendered unconstitutional by an expanded court. In that way, we can immediately undo the damage done by this particular decision. Then further, there needs to be a suit that claims the rights, okay, of women, the privacy rights, okay, of women in consultation with their doctors, and placing regulation of that off limits to the state. And that kind of decision from the Supreme Court has to be made by the expanded majority of the court in relation to the Equal Rights Amendment. It has to be justified in terms of the Equal Rights Amendment, okay, which, by the way, has to be immediately published by the government so that, okay, it's official. It now is unofficial because the Biden administration has refused to publish the new amendment, in spite of the fact that it's been ratified now by 38 states. That has to change. there must be great pressure placed on the Biden administration to do that as soon as possible. The recent attacks on the rights of women have to be repealed. The rights of women must be quickly restored. And the packed court has to support the constitutionality, of all this. Only then can the court be put in its proper place. Even then, there would be, I would argue, one more thing to do. At least we ought to contemplate this. And maybe different people will rule in different ways about this. For example, Jamal Bowie might consider that if we require a supermajority of the court to declare things unconstitutional, that's enough in relation to protecting the legislative branch and the executive branch and the people from outrageous decisions by the Supreme Court. But there's yet another reform that could be put forward, and that reform could be that the Congress could pass a law that would assert specifically that the power of judicial review has not been given explicitly to the Supreme Court, that is not in the Constitution. It was an inference by the Supreme Court itself, by John Marshall, without the consent of the other branches. And that it is the opinion of the legislature enshrined in this law that while the Supreme Court can have the power of judicial review, it cannot be an exclusive power of the Supreme Court. And if the Supreme Court declares certain laws and decisions unconstitutional, in the view of Congress, that particular decision must require but further ratification by the Congress. Okay? And the Congress claims a veto power over such opinions, rendering them as advisory. I think that change would also be a very good change to make. I think the Congress, when it comes to law, the legislative branch has to have the final say, and the view of the Supreme Court should be an advisory view. Its function should be an advisory function. The Congress is the first branch of government. The Congress has within it the People's House. It should not be possible for the Supreme Court to contravene the view of the People's House. Unless we're going to change the Constitution to provide for the direct election of the justices of the Supreme Court, they should not have the power, the absolute power, to contravene, the decisions of the elected branches of the government. This is either a democracy, or it's not a democracy. If the will of the popular branches can be contravened by a non-elective branch, then what we have is not a democracy. We have to recognize that. We have to face that. And if we want a democracy, we have to change it by using the methods that Bowie and I have now proposed. That's all there is to it. If we want a democracy, it has to be a democracy. There cannot be an oligarchy within it that can contravene the will of the popularly elected public servants. That's it. Okay, so that's what I want to say about that. So I will now turn to your questions and comments. Oops, hang on a second. I might have gotten a message. Nope. Okay. So I do have some comments or some questions. Kay says, trying to do a few things at once. I think I'm getting a smile from Steve Day, who's here. Hi, Steve. Kay says, Biden better bring up the end of Social Security, okay, and Medicare. He better bring that up as an issue, that those things are certainly currently threatened. Kay says it's not a democracy anymore, in my opinion. That's right, Kay. It's not a democracy anymore. We have to recognize that. We have an inverted totalitarian system, especially with the way the press acts, basically acts as a servant of the oligarchs. Any other comments or questions? Hello, Sandy. Good to see you here. Thank you very much for coming. I'll wait a moment to see if you have any more questions or comments. If you don't, then I will call it a night. While you're thinking about that, tomorrow we will be covering some very interesting things. Russell Gorman says, where can I read more on inverted totalitarianism? Look up Sheldon Wallen's publications. Just look up Sheldon Wallen. There's a Wikipedia article. I've given you the spelling below. Oh, so Kay says, thank you, Joe, for being here for us. Yeah, I really love to be here for you. I really do. I really enjoy it. It's Wallen with an N. Make sure I did that right. I think there's also an article on inverted totalitarianism itself, which gives references to his own work. Oh, Sandy gives me lots of hearts. Thank you, Sandy. That's inverted totalitarianism. There's an article about that. One particular, okay, Sheldon Wallen was a political theorist who taught at Stanford for many, many years. He died fairly recently. I believe it was within the last 10 years or so. Okay, I remember seeing good books by Sheldon Wallen going back to the 1950s. He wrote a book, I believe this book was in the late 50s or early 60s, called, okay, the name of it was Politics, okay, and Vision. It was an extended interpretation of some of the greatest of the political theories. It was a very, very good book, recognized as such at that time. But his thinking about totalitarianism, okay, and his writings on that subject during, I believe, the 1990s and the first decade of the 2000s, before he died, were very, very good works. And of course, the idea of inverted totalitarianism is a new and very useful notion. The biggest fan writing of Sheldon Wallen, who I believe was his student at one time, is Chris Hedges. And Chris Hedges has written a bit himself about inverted totalitarianism. I think Wallen's model of inverted totalitarianism pretty much describes the United States under the conservatives in the Republican Party, like, I don't mean like Trump, okay, I mean like the Bush family, okay, and their allies. Even though they were very conservative, they became recognized eventually as the establishment Republicans during the last 20 years or so. They ran the country as an inverted totalitarian system. And the Democrats have run the country as an inverted totalitarian system, starting with Bill Clinton. And every Democratic president has run the country that way since Bill Clinton came into office. So rather than the fascist model, though it has a lot in common with the fascist model, I don't believe the way the Democrats run the country is an example of open fascism. I think the inverted totalitarianism model fits this a lot better from the standpoint, okay, of theory. Now, that doesn't mean it's any less bad than fascism in terms of its effects. Okay. For example, if the Biden administration keeps on taking the risks it is taking now and running the kind of foreign policy that it's been running now, we may all be deader than doornails in the next a few years. That outcome cannot be worse for us. It cannot be worse than the outcome that would be produced by an open fascistic system. Inverted totalitarianism shares a lot with fascism in terms of its characteristics. Lisa and I, in previous live streams, have gone over the characteristics, okay, of fascism. And except for the fact that inverted totalitarian systems are more subtle in the way they isolate people, are more subtle in the way that they punish people, are less openly brutal. They are, in many essential ways, quite similar to fascist systems. So, by calling them inverted totalitarian systems, I'm not excusing anything, and neither was Sheldon Wallen. He did not mean to suggest that inverted totalitarian systems were any less horrible than openly fascist systems. I have to say that I think the fight between the Trumpists and the Democrats today is sort of like a fight between inverted totalitarians and open fascists. Life may be a bit more pleasant under the inverted totalitarians, but as time goes on, we can see that it's just as deadly. So, anyway, those are the references. Chris Hayes. Chris Hayes loves Sheldon Wallen's work. So there we are, Russell. Any other questions or comments? This is kind of open Q&A. Steve Day says, love to buy in, Joe. Well, thank you, Steve.
Thank you.
And Russ says, and there is a clear intermixed of state and corporation. Absolutely, as there is in openly fascist systems. So in that way, the two types are quite similar. There is perhaps a greater mix of the press and the government, a more subtle mix of the state and the mass media corporations, so that on the surface, it seems like the mass media are not an openly propagandistic arm of the government. But we know very well by living under it. Oh, and boy, one great case for that is this Ukraine war. It's very hard to say things in opposition to the Ukraine war and get any spread from the mass media to any mass audiences. It's all suppressed. It's all suppressed. We know we're suppressed. We can see it clearly, okay, on Twitter. But some of us who've been, well, in a way, Facebook is less exacting than Twitter. In other words, there are some of us who Twitter has, somehow identified, and it's taken years for our followers to grow, okay, on Twitter. I mean, I've been close to having 2,500 people follow me on Twitter for ages and ages and the total never gets higher. I know new people are following me all the time because on a day-to-day basis, I'm getting notice of the follows, but I can't get over the title of something like 2,450 followers on Facebook. In Lisa's case, she's been frozen at something like 14.4K followers forever. And I know she's getting new followers all the time. So they have systems for limiting the people that they identify somehow, okay, as dangerous. And of course, they don't limit the representatives of the mainstream. That is certainly very, very true. What is somewhat encouraging is seeing people like Colonel McGregor and Colonel Scott Ritter and some of the other people who obviously know the real military facts, okay, of the war, okay, in Ukraine. Also Larry Wilkerson too. Uh, okay, and some of our streamers who have managed to get them on and who are getting them talking, okay, and telling the truth. But a lot of the people who have them on are people from uh, from other countries, from the UK, uh, you know, people from Ukraine itself, but people from Greece. Uh, they're able to find some other outlets to get these people on. But Jackson Hinkle was very severely disciplined for talking to these kinds of people, okay, in recent months, to the point that I understand that uh, he's been thrown off Twitter permanently. I think that understanding, okay, is actually correct. He's gone on to other platforms and he's doing very well, but a lot of his following now is now international. Okay. So, anyway, a bunch of highs all around. Steve Ghoststart is here, and he says, "Hey, at Steve Wolfbrand, at K Ryan," and Steve Day says, "We are danger, laugh out loud." Well, they consider us so. I don't think we are danger. I think we are the lifeblood. If there's any lifeblood left of this so-called democracy. Ghostart says he's still on the twit. Okay, thank you, Steve Ghostart. I thought he had said at one time that he was not on Twitter any longer, that they had banished him. Maybe they relented, or maybe I just have it wrong. Anyway, we are at 9:57. If you have some more questions, okay, I will entertain them. I will give you a moment or two to ask them. But I think we are nearing the end for tonight. I guess I was about to say before that for tomorrow, okay, I believe that we are going to be doing. Okay, for tomorrow, the 9 o'clock show now. I'm talking. I'm not sure what news is, going to arise during the day, and I may be picking that up. But the main show at 9 p.m. tomorrow will probably be on interest rate terrorism. And there we'll be going over some articles from the Peter G. Peterson Foundation. Uh, Also, an article on the global inflationary tsunami. And those two articles will be exposed to vigorous commentary by myself and by Lisa if you can join me tomorrow. So those are the coming attractions for tomorrow. I will also have some other pieces that I'll be picking up in the morning or later tonight. That I will be doing analysis and commentary on, but during the day tomorrow. And maybe during the early evening, as I did here today. Okay, I did a stream at 3 o'clock, and I did another stream at 5 o'clock. And then this stream was the third stream, okay, of the day. So, I think that is it for tonight. I should remind you of my Patreon account, which is displayed on the screen, and remind you also of my Buy Me a Coffee account, the link for which is on the stream. Steve Wolfbrand points out people here are already voting. And Ghostart says that Eva and Patrick are on the ground, okay, in Ukraine. Yes, I know. Eva Bartlett, if I'm not mistaken. Steve Wolfbrand says people here are already voting. Yes, people here are already voting. Ghostart said he was monetized everywhere. Yes, demonetized everywhere. Yes, I understand he was. Probably that's what confused me. He wasn't actually banned from the platforms. He just was demonetized, so he wouldn't be able to make a living. So he turned to make a living from other sources. And Steve Ghostart said, Dan Cohn's doing good work on Haiti. Yes, I believe he is. Steve Wolfbrand says, I miss Lisa. And we miss Lisa too.
Yes.
Don't know what was going on with her today, but I'm sure I'll find out. But tomorrow, hopefully, she will be here tomorrow. And hopefully, she will be here on Thursday as well when we have a lot of election news. Of course, the election picture is getting hot. Kay says, I'll vote when I get my ballot in Ohio. Steve says, good night, all. Stephen Wolfbrand, this is. Good, Steve. Thank you for coming, and we'll hope to see you tomorrow as well. Kay says, thank you, Joe. Sandy says, I sent in my ballot. Kay says, good night, and I love you all. We love you too, Kay. Sandy Degg says, have a great night, everyone, and leaves us 4 hearts. Kay Ryan says, you too, Sandy. Steve Gostart says, good vibes. Yes, very good vibes. And Sandy Degg says, thanks, Kay. So everybody, good night. And Bonnie and I will certainly see you tomorrow. And hopefully Lisa will be here too. Teresa said, my chat just appeared in time to say good night. Weird. Yeah, that is kind of weird. I don't know what's going on there, Teresa, but it is very nice to see you. Okay, even if we are closing out, okay, at this point. But as I said, there'll be 3 streams tomorrow and 3 streams on Thursday, and there will be 3 streams on Friday. Okay. So there's going to be a lot of activity. We are doing 15 streams a week now. And we're going to keep on doing that. But we will be taking Saturday and Sunday off. So have a good night, everybody. And we'll see you tomorrow.